This case study focuses on Oyster Group versus MSC Consulting. Myself, Emily, will outline the facts and timeline of the case. Next, William will analyse the respondent's argument and the legal issues that were determined. Karn will discuss the outcome of the case, and Callum will provide proactive property management recommendations. Initially, MSC Consulting structural engineers undertook an assessment of the building owned by Corinthian Drive Investments. They created two structural assessment reports of the building. The initial assessment rating for the building was 72%, and the detailed assessment was 87%. In 2012, after ANZ had seen this detailed rating, they entered into a 9-year lease on the $27 million building. In 2014, Oyster Group purchased the property from Corinthian Drive Investments. However, later in 2017, ANZ engaged with Becker Engineering and Consultants. They provided an assessment which rated the building below 20%. This further led to ANZ moving out so that repairs could be undertaken, which resulted in the vacancy of the building.
The respondent's argument. So as Oyster Group took MSC to court, MSC responded with these arguments. First was the strikeout. MSC applied to the High Court to have the claims against them struck out entirely. The second was the no duty of care. MSC further argued it had no duty of care to third parties as it had a limitation clause in its agreement restricting the report's use with a third party. The third was negligence was time barred. MSC lastly contended that the issue was brought forward too late per Section 393, subsection 2 of the Building Act 2004. The issues determined. The strikeout clause. The initial application to have the claims brought against MSC struck out were denied by the judge. No duty of care. Justice Timothy Brewer acknowledged the limitation clause's use with third parties, meaning the report's relevance when used in conjunction with a third party was irrelevant. The third, it was the time barring. Justice Brewer also accepted the time barring claim under the Building Act, which gives the plaintiff no more than 10 years to file a complaint. Now on to Karn.
Justice Timothy Brewer. MSC argued the negligence claim was time barred under the Building Act of 2004. Essentially, MSC stated Oyster Management's allegations were disallowed or invalidated on the grounds that a time limit had expired under the Building Act of 2004. Additionally, to support MSC's claim, Justice Brewer stated Oyster did nothing to confirm its correctness. Justice Brewer further stated, although the initial MSC report was only 2 years old when shared with Oyster Management as a part of purchase negotiations, Oyster Management did nothing to confirm its correctness despite seismic resilience being important to the building's commercial function. However, MSC attempts to strike out Oyster Management Limited was declined by Justice Brewer. Instead, High Court and Justice Brewer accepted MSC's argument that Oyster's negligence claim should be struck out because it was brought too late as outlined in Section 393(2) of the Building Act 2004. This section prevents civil litigation relating to building work if the lawsuit was brought 10 or more years from the date of the act or omission. The act or omission relating to the design of the building was completed in 2004, meaning the period when Oyster could sue MSC was no later than 2014. Outcomes determined. Oyster Management sued MSC, alleging MSC Consulting earlier reports contained negligent misstatements and claimed MSC was negligent. Oyster sued over 2 reports, claiming an initial assessment of 72% and a detailed one at 87%. In effect, these reports caused massive losses for Oyster Management as ANZ had to vacate and the cost of repair for the building. MSC Consulting then applied to High Court Justice Timothy Brewer to strike out these allegations made by Oyster Management. MSC stated its reports had a limitation clause, stating it was not intended for other parties and it declined Oyster's previous request to include it in the prospectus, although Oyster did mention it in the investment document.
As we can see through this case, BNZ's corporate real estate strategy was to lease the premise from Oyster so they did not have to worry about the property management. It is important to note Corinthian Drive Investments and Oyster Group conduct real estate for the purpose of their business. Therefore, it is not corporate real estate. It is also important to understand BNZ's corporate real estate strategy, as it is very likely they would have been able to purchase the building alone. However, in the corporate real estate sense, you have a wide range of moving parts, this including finance, operations, HR, and of course, costs. Therefore, due to the difficulty of realising potential revenue benefits, for example, a fit out to enhance BNZ staff enjoyment and convenience, BNZ's corporate real estate strategy was to just lease the premise. However, due to BNZ's corporate significance, they would have likely had strong negotiating terms, this including a bespoke lease and favourable tenant terms and clauses. This likely including specific new building standards for seismic ratings and also a maintenance caveat. For example, if maintenance issues persist, they can stop paying rent and can vacate the premise with reasonable notice. Also, due to BNZ's size and offices in Auckland, they tend to have resilience play, meaning that because this one site was down, the business was able to function due to the other sites. Therefore, in this case, corporate proactive property management is crucial, and not only in maintaining the relationship between the landlord and tenant, but also making sure the correct due diligence is done before the acquisition. This is to ensure risk is minimized and revenue streams are maintained. Some examples of proactive property management which could have been conducted includes correct inspections and reports, for example, engineer reports and building inspections, routine maintenance, including foundation assessments and overall standard inspections, and then also remediation. Oyster could have remediated this issue in a more timely and effective way. This in turn creating a positive relationship between the tenant and landlord, this being mutually beneficial, likely leading to a longer lease and less vacancy in the future.